Thank you for joining today. We're talking about applications in the Court of Protection, why we might make them, what they're for, their purpose, how they operate. I will start with a little distinction between the Court of Protection and the Office of the Public Guardian and the associated applications. The Office of the Public Guardian deal with those applications for lasting powers of attorney, registration of enduring powers of attorney, those documents being ones which have been prepared by the donor of that power while they have capacity. So historically, we would take instructions, prepare lasting powers of attorney for 2007 enduring powers of attorney. They will then be registered with the Office of the Public Guardian for use later on. They are prepared for clients who have capacity while they are giving those instructions, and they are choosing the attorneys they would like to act for them in respect of their property and financial affairs, and since 2007 also the health and welfare elements of their affairs when and if they become incapable of making those decisions for themselves. The distinction being that those applications are made by a client who has capacity and they are choosing who they want to act. The Court of Protection operates in the sphere where the client has already lost capacity or indeed the ability to communicate their decisions. And the Court of Protection is a more convoluted process. The reason being that it is an application to a court. It is a potentially contested court process because an individual or more are asking to take control of the affairs of Court of Protection, call them a patient who has indeed lost their capacity. The idea is that we should all look to try and complete a lasting power of attorney, or indeed use an old enduring power of attorney if created prior to 2007, in order to ensure that we have chosen who we would like to act for us in the event that we lose capacity. But frequently that doesn't happen. People do not do it, or there are problems with the documents that were prepared earlier, and therefore we head down the route of applying to the Court of Protection for a deputyship order. The Court of Protection deals with the application, which is for either or both types of deputyship order. There is a deputyship order for property and financial affairs in the same way as you can have a lasting power of attorney for property and financial affairs, and indeed for health and welfare matters. Historically, the application for health and welfare matters has been far less successful in terms of the court are reluctant to generally appoint an attorney to look after the health and welfare of, for instance, an elderly relative, without there being specific decisions that the person has to make in respect of prolonging the life expectancy of that individual, taking really critical decisions around emergency surgeries or actions, indeed protecting that individual from other people in the family or other organizations. They are starting to issue more health and welfare deputyship orders, I think, as they realize that people are using them in the way they were intended and are not abusing them, but still it's in single figures of tens per year, whereas there are several tens of thousands of property and financial orders issued by the court annually. The other sorts of applications you can make to the Court of Protection include that of making a statutory will. This is for potentially for a patient, as I say, as they call them, who has no capacity to give instructions in respect of a will, but the family realised that had a will been prepared, or had the individual gone ahead and given instructions to do a will, that it would be very different to the intestacy rules, or indeed different to the will that does exist. You can make an application to the Court of Protection to create a statutory will. There is, again, I'll talk through the process in a moment. It is a convoluted process and without question much more expensive and difficult than doing it right the first time and updating wherever possible. The court fee alone is probably around about the same cost as preparing a will from scratch. So to be avoided where possible, but these are the sorts of applications that one can make. If we talk about the statutory will first, because it's probably slightly less common and less known about. But one can create a statutory will. It can be simply for the purpose of inheritance tax planning. It can be for the purpose of disinheriting somebody who would be chosen to be disinherited by the individual if they had capacity. It is normally done where the intestacy rules would otherwise apply and there would be a significant inheritance tax burden on the estate. The court do grant these applications. There are various steps through which one must go. You need to apply normal application forms to Court of Protection, a COP1 form. There needs to be a witness statement prepared by the person who is applying. And all of those people who would otherwise benefit under the terms of the either existing will or under the intestacy rules need to be contacted and have their consent sought to that statutory will application proceeding. As part of the process, we lodge a draft of what we anticipate the will would look like if permission is granted to have the statutory will, and go through those processes. It is, again, as I said earlier, a contested process. You will often have that maybe somebody doesn't want to have their entitlement removed for obvious reason, because they think that is something to which they are entitled, and they need the money just as much as maybe the other siblings or the mother or the father or the friend do, and they refuse to give consent. And at that point, then if everyone continues down that route of wanting to prepare the will and wanting to contest it, it will be heard in the Court of Protection as a case, effectively in a court case, where both sides are represented, and lots of funds can be spent on trying to ensure that the will is drafted and signed on behalf of the patient, or indeed prevented from being signed and drafted on behalf of the patient. It is something to try and avoid wherever possible. We do statutory will applications. We've done a couple recently where the family are all in agreement. They wanted to do it so that there was a reduced inheritance tax burden. They go through without being contested. They still take a long time, but they're straightforward in terms of the actual process and the court process, but there is a length of time that does pass, sadly. So we do encourage people to do their wills before they lose capacity wherever possible, for obvious reasons. With regards to the other applications which are common in the Court of Protection, the health and welfare application and the property and financial affairs application as a deputy, there is a suite of forms that need to be completed. There's an application form, there are witness statements, there's documentation around the deputy, the proposed deputy or deputies, around what their employment is, how long they've lived in their house. The court will make checks to ensure that the individual or individuals being proposed are suitable to act as deputies, that they don't have bankruptcies against them, that they are people of generally good character, because you have to bear in mind that the power that these individuals or organizations have over the affairs of somebody who has lost capacity is significant. So the court do not want to go and appoint, for instance, somebody who is an undischarged bankrupt to look after the financial affairs of a relative, because they would only be criticized in that situation. Not to suggest that the bankrupt would do anything incorrect. These things happen by mistake, and do not require any intention, but the temptation could be too great. The court will not appoint an undischarged bankrupt as a deputy. The key thing with all of these applications in the Court of Protection are to demonstrate that the patient has lost their capacity. We have people come to us, they'll give us a doctor's note from the GP saying, oh, mum's lost capacity, can we start? Yes, of course we can start, but there is a prescribed form which needs to be completed in order for the court to even consider whether they will grant any form of order in respect of the patient, and that is a form COP3. It needs to be completed in that form, and it needs to be submitted as part of the application to the Court of Protection. Whenever we're instructed, we will obviously sit down with the proposed deputy or the proposed person who's going through the statutory will application. We'll explain to them what the process is. We'll go through an element of what the forms are and the sorts of information that will need to be collated. But we always advise people to get that form COP3 completed at the outset, really at the very earliest opportunity, because it does happen that the medical practitioners come back and say, no, actually, the patient has got capacity. They are able to understand the questions that you are going to put to them in this process, and they are able to communicate their decisions, and therefore, and in fact, a deputyship application or an order to the Court of Protection under any guise is not the appropriate application to be made, but they can potentially draft their will and give instructions for that, and may be able to create lasting powers of attorney. So we always do advise that Form COP3 form is completed right at the outset, because it seems a little bit silly to take instructions to head down that route of making the application to the court, spending time and money to get to a point only to be determined later that the person has capacity, and we shouldn't have gone down that route at all. So we do encourage that. Once we have that, we will sit with the proposed deputies of the family members, whoever's getting involved in the statutory will, and we will go through all of the patient's assets, their liabilities, their income, what their needs are. The forms require all of this information. So you do need access to bank accounts, to not to the accounts themselves, but to the statements, information relating to any benefits being received, a likely potential valuation of the property if the person is in care. What are their care fees annually? What are the other associated costs related to their care, which add up to quite significant sums at times? The reason being that the court wants to know the complexity and the nature of the assets related to the person for whom the application is being made. Is it simply that the person has one significant bank account and a property, or do they have assets scattered around the world and various trusts and lots of complicated income producing vehicles? Because the court will supervise deputies. They will always, for any deputyship application, for a property and financial affairs application, a deputy will only be appointed after taking out a security bond through an insurance company. They used to use Howdens, but they've now moved to some other brokers. They have a range of brokers, and you have to, as a deputy, take out the insurance bond to protect those assets against mistake or against deliberate removal by a deputy. And then they will provide the order. But the anniversary of the granting of the order, they will also be asking for a set of accounts for that entire year, from the date the order was granted through to that 365 days later, to show exactly what decisions have been made, to show exactly what money has been spent, and the supervision that they need to apply to each of those cases will depend on the complexity and the nature of the assets of the patient. If it is as simple as a bank account, they know that what they're going to receive is a bank statement each year, which will show the interest which has been accrued, and there may even be a tax return if the interest is significant, or if there's rental income because they've chosen to rent the property out. Versus something where you have a complicated investment structure with properties in different jurisdictions, they know that the information that they're going to have to look at will be far more significant, and therefore they set their supervision fee at a greater sum, a higher sum, so that they can ensure that the time they are spending on it, they're being sufficiently remunerated for. So it's a very brief outline as to the sorts of processes, the sorts of considerations one might have. None of it replaces doing these things in good time, which we obviously encourage people to do wherever we can, but we understand that this is not possible. It doesn't get to the top of everyone's priority list, and indeed, terribly catastrophic events do happen, which mean that somebody who would not have expected to need these things yet do need them. So, if you need any advice in this space, we're always happy to sit down and have that conversation, talk through the forms, look at what the next steps are and the processes are. And we work with, we are also deputies for people. We work with financial advisors about how do we look after the assets for the deceased, for the patient, and make sure that the level of care that they require can be met for as long as we anticipate it will need to be met, and longer, so that the individual can continue to have sufficient level of care. Which is crucial, really, because where we're appointed, it's largely because they don't have any family, and we need to make sure that those people are properly looked after through to when they're no longer a patient, but then they are sadly deceased. So that's sort of a whistle-stop tour through Court of Protection applications. please do give us a call, drop me an email if you like, if you have any queries, if there's any further information you would like. And I'm also happy to take any questions either in the chat, although I can't see any in the chat at the moment, or through the Teams call if you have any questions. Thank you for listening.